And now, Ralston Reports.
Welcome back across Nevada to Ralston Reports. Even amid the call for a review of the nation's Stand Your Ground laws, Nevada lawmakers who overwhelmingly approved a no duty to retreat law in 2011 are standing their ground, claiming Nevada's law is not the same as Florida's. Here to go face-to-face and talk about it, Assembly Majority Leader William Horne, and from the Progressive Leadership Alliance of Nevada, Laura Martin. Welcome to both of you. Thanks for coming on the program. I think the two of you actually have very different perspectives on this, just based on your tweets right before the show. Twitter it tells you a lot of information. Plan, your group, tweeted this is 26 states, including Nevada, that is ALEC, which is a very conservative group, and the NRA campaign. And you said, I'm coming on Ralston Reports to show them the difference between the two laws. I'm going to let you both make your case. Why is the law here different than Florida?
Well, you keep calling it a stand your ground. I mean, here we've always had a no duty to retreat. And there's a difference that they have in Florida where basically it doesn't matter if you're the original aggressor or not. If it rises to a level to where you become fearful of your life or serious bodily injury, you can use that law in Florida. As you said in your Twitter when we were going back and forth, you believe that if George Zimmerman had done the exact same thing in Henderson or Green Valley, we would have the same result. And I disagree with that, because I believe that Mr. Zimmerman's actions in Nevada could be constituted as the original aggressor, and he would not have been afforded that protection. And that's a distinction that is significant that you don't believe it is.
Well, we'll get to what I believe in a moment, if anyone cares. I'm going to show the laws in a moment, Ms. Martin, but do you think there is a significant difference between Nevada and Florida's laws, and between what the NRA was which was involved in this, I'll show that in a minute, and what they did across the country?
There's a slight difference, but I think that what's key to remember in what we have and what happened in Florida and what might happen in Nevada is George Zimmerman's lawyers got the jury to believe that Trayvon Martin was the original aggressor. And that's the issue that a lot of people have, is that, fear, be it reasonable or not, that certain people have of other certain people. And so that's why people are now really worried about what this law means here in Nevada.
Well, they did not use the Stand Your Ground law as defense. It was a pure self-defense case, although in the jury instructions it was mentioned. But what
that's what makes it a fiction. When people say they didn't use the Stand Your Ground law, but if the jury gets to consider it in their deliberations.
Yeah. But originally he was not arrested. You remember that, because of the Stand Your Ground law,
right? Yeah, but the
right?
jury instructions almost verbatim are the Stand Your Ground law in Florida.
Let's show people, instead of just listening to you guys, let's show people what the laws actually say, and let them judge for yourself, and then we'll argue about it some more. Here's what the Stand Your Ground law says in Florida. A person who is not engaged in an unlawful activity and who is attacked in any other place where he or she has a right to be has no duty to retreat and has the right to stand his or her ground and meet force with force, including deadly force, if he or she reasonably believes it is necessary to do so to prevent death or great bodily harm to himself or herself or another, or to prevent the commission of a forcible felony. That is exactly the ALEC language that they wanted across the country. Nevada's law is different. As Majority Leader Horne said, here's what it says. A person is not required to retreat before using deadly force as provided in subsection 1 if the person A is not the original aggressor, B has a right to be present at the location with deadly force is used, and is not actively engaged in conduct in furtherance of criminal activity at the time deadly force is used. I'm play devil's advocate with you here, sir. The practical effect is the same. If indeed, no one knows what happened that night except for George Zimmerman, so let's just use that case. As Ms. Martin pointed out, the jury became convinced that Trayvon Martin was the initial aggressor there. That is part of the reason George Zimmerman got off on either second-degree murder or manslaughter. So if that happened in Green Valley, as I suggested, he could invoke the Stand Your Ground law.
Well, I don't believe that the jury had to get to they believe Trayvon was the initial aggressor. In Florida, you don't have to be.
It says if you're attacked, it's the same thing.
No, it's not the same thing, because original aggressor in Nevada, in my neighborhood, if a George Zimmerman did all the same things that he was doing in Florida, in Nevada, then I'm afforded that. George is not afforded that
You're saying he's the aggressor then just because he's following you?
Okay, the difference between you and me is you don't get followed around in your own neighborhood or in a shopping mall.
This is a different issue, and I do want to talk.
It's not a different issue. It's the same.
That's a societal issue. That's a young black man being profiled, etc. Right?
But what it is in the perception of the jury. You know, if I'm following Jon Ralston in his neighborhood, does somebody believe that I'm the initial aggressor?
You can't be called in Florida. It's not illegal to follow anybody.
In Florida and Nevada is two different things, and I'd like to know where in any neighborhood watch manual where it says, get out of your car, follow.
I'm not saying that George Zimmerman said was right. Don't put me in the position that I'm not defending George Zimmerman.
But what I'm saying,
I got to let Laura Martin jump in.
There are differences.
Will you please tell him that he's wrong?
No. I think the key to remember what she read in both laws was the word reasonable. Not everyone is reasonable, and there's different degrees of being reasonable. And I think as we go back to Nevada's law, you know, we get together with our member groups. We have about 30 member groups, and we decide what laws we're going to deal with, what we're going to push for, and what we aren't. And this is obviously something, you know, a lot of our member groups like Progress Now Nevada, the NAACP are really concerned about.
You want it repealed?
We're going to decide that with our member groups. We want to have a community discussion first to get some legal people to explain this. We would love to have you there as well to kind of have a community discussion to talk about what does this law mean? Are we empowering people to be vigilantes, or are we giving people too much trust to be reasonable?
All right, we're going to take a break. Now, I know you want to keep talking. You're going to want to talk a lot. I've never seen William Horne this worked up. I love it. Must be because he's not running for re-election. Stick around.
And now, Ralston Reports.
Welcome back across Nevada to Ralston Reports. We're talking about Stand Your Ground. That's the controversial Florida law. It exists in about 24 other states, including Nevada. Is there a difference between Nevada and Florida law? We're talking about that with PLAN's Laura Martin and William Horne as the majority leader of the Assembly. I've looked through all the minutes. I've looked through the floor speeches, and there weren't any, by the way, on this. Nobody said boo about this when it passed in 2011, Ms. Martin. PLAN was nowhere to be found. The ACLU initially was going to be in opposition, then went neutral on it. It's now only after what happened to Trayvon Martin, suddenly everyone's like awaking and saying, oh, we need to review these laws. You guys didn't have a problem with it in 2011, did you?
I think in 2011, it was kind of unanimous on both sides that this was just going with what's in our Constitution. This is going back between a fight with a man named Kennedy, and it was just, I guess, of fixing something. And I think, you know, maybe it was a mistake at the time not to look at it more closely. I know at the time people weren't scrutinizing ALEC bills as closely as they are now, and maybe didn't realize what was happening.
Just in case people don't know, ALEC is the American Legislative Exchange Council. It's a very conservative group. They have model legislation, very conservative legislation. Some of it's been brought to Nevada in other instances too. The late Bill Raggio, may rest in peace, loved ALEC, used to bring back their model legislation. They were in partnership, a lot of people thought, with the NRA bringing this around the country, right?
Yes, a lot of people do believe that, and I just think that unfortunately what happened to Trayvon Martin in Florida woke a lot of people up. I mean, there's a group of young people called the Dream Defenders who have been occupying the governor's office for 5 days now, wanting to take a look at the law. You know, they weren't able to stop it in Florida, but people are willing to do something now. I mean, we're not perfect. We try to be. We wish we were, but if we can fix something now, we can at least take a look at it now. Back in
2011, let me just give people the background here, just so people know, Mr. Horne. You're no darling of the NRA. I think you have a 17% approval rating.
Is that high?
Yeah, it is that high. But you were chairman of the Judiciary Committee in 2011, where this bill went through, and it wasn't controversial. Only 3 Democrats in the entire legislature ended voting against it. I guess they were the principled ones. Okay, that's a joke. Anyhow, the bottom line is the NRA was involved here. This was portrayed as some kind of innocuous, we're just codifying a Supreme Court decision from about 10 years ago. But here's what the National Rifle Association wrote to lawmakers in 2011. They sent letters to each house. Nevada case law already makes allowances for this debate, and then they refer to the Supreme Court case. In self-defense cases where juries are instructed that individuals have no duty to retreat. However, memorializing this language into the Nevada revised statutes is a major step in the right direction for citizens of the Silver State. The NRA wanted this, just as they did in all the other states Ms. Martin has talked about.
I don't care how the NRA characterizes this as a win for them. This has been in our state for 140 years. This has been the standard.
In common law or in case law.
But
you're talking about the castle doctrine.
You were talking about,
no,
you're talking different things, John.
Okay.
We're talking about we're talking about in terms of self-defense. This standard has always been. And if you look, and I don't know if you looked thoroughly and looked how the bill was amended slightly to add that language on actively, involved in a crime. It couldn't be actively involved in a crime.
That just means if you have a joint in your pocket, you're not.
But these are important distinctions. What you didn't see, what you did research on, are the bills that did try to do the ALEC version on. There's been a bill in 2011, there was a bill last session trying to do that very thing. It changes to presumptions of, like, in the real stand your ground laws actually changes that presumption to, it shifts. The presumption is that killing, that homicide was justifiable, and the DA now has to change it. And that's the difference that you miss in comparing
It's not
the
the
two.
first time people have said that I've missed things. But listen, you're the lawyer here. I only play one on TV. But we actually talked to another lawyer. David Figler was on this program earlier this month, and here's what he said about the Nevada and Florida laws.
Really, both states have the same sort of exemption for the individual who has done the shooting, and that is they can't have anything to have done with getting into that situation. In other words, they can't be the original aggressor. That's number one. But further, in the statute that you just read, which is just a codification of what the Supreme Court has ruled for years, you can't really have manipulated the situation or make the situation where a confrontation would be likely. So in Zimmerman's case, if he was here in Nevada, one could argue, if the prosecutor would say, look, he was looking for a fight, he was looking for this trouble, the police told him not to go and he went anyway, so this is of his own making. The confrontation was of his own making, so he doesn't get the benefit of self-defense to make it a justifiable homicide.
Well, that's a good lawyer. He could argue both sides of it. He agreed with you and disagreed with you in the same soundbite. I guess what I'd ask is, some people would say that the premise behind the stand your ground law, or whatever William Horne wants to call it here, makes sense. As you heard David Figler say, doesn't it make sense to you, the premise?
I guess the premise makes sense. I think people should, be able to feel safe. But again, the question is with the term reasonable. I mean, Plan has canvassers out right now. What if somebody feels like they're in danger because someone rang their doorbell and they don't recognize who it is? Do they have a reason to shoot them?
Well, we're going to come right back. There's some other issues to talk about here. We're back with William Horne and Laura Martin in just a second. Stick around. Welcome back across Nevada to Ralston Reports. We're talking to Laura Martin of Plan and the Assembly Majority Leader William Horne about stand your ground laws in the wake of the Trayvon Martin, George Zimmerman controversy. You mentioned something earlier, and this really has struck a chord, and the president, I thought, gave a beautiful speech when he finally came out and talked about it. African Americans, males, and African Americans with children, especially young males, are reacting in very visceral way, I think, to what happened. I think you are too, are you not?
I think I am, to a sense in that we internalize, our life experiences. And as I've told people, I had a conversation with my 10-year-old son, the same conversation that my father had with me when I was 10 in 1972.
Which was, we're running out of time, tell me quickly.
Which was about how a black man, a black teenager, male particularly, has to conduct himself and protect himself in public in order not to be an accident. And I think that's what stems from when Stephen Horsford says we have to revisit these stand your ground law. And that's what legislators do. We pass things, and then if we see that there may be a problem,
you think there's
we
a
go
problem
back
with
and
this
do it. I don't. In Nevada, I don't. I think that's what we should be able to protect ourselves.
We only have a few seconds left. Do you understand where he's coming from on something like this?
I definitely understand. My father's black. I have 4 brothers, and I just think, since we've been in this country, we've been fighting for people to recognize our humanity. And I think that's what happened on that night in February last year, was George Zimmerman saw somebody walking home in the rain and didn't recognize his humanity. And unfortunately, he's no longer with us. But the good part is now he's started a movement to start looking at, things that are going on in our country.
That's a great place to end it. I really appreciate your coming on, Laura Martin, and you too, Mr. Majority Leader. Thanks for coming on the program.
Thanks for having me.
Thanks for watching, everybody. Have a great evening.